Hi there. This is about escrow agreements. So what is an escrow agreement? They're quite common actually, particularly in real estate where the money can be put with an independent party pending the conditions being fulfilled, normally the transaction going through. Mergers and acquisitions, similarly you can hold all the documents in escrow against payment of the price, or post-closing or completion you can hold the retention amount against any potential breach of warranties. Similar in construction contracts, you see sums of money placed in escrow as security against a claim for breach of warranty. Documents, various documents of title, cashier's checks can be held physically by the escrow agent. Source code escrow, it's where you have business critical software and you're worried the developer might go bust. There are various escrow agents who will hold the software in escrow so that you can carry on adapting and developing the software if one of those release events such as going bust takes place. And lastly, and this is what I'm going to talk about in a minute, domain name escrow, very common for various, quite cheap actually, escrow agents to offer placing a domain name into escrow pending the transfer being completed. But the interesting thing, what I wanted to talk about today, is a bespoke escrow agreement. We're quite often asked to do bespoke escrow agreements, and this was in relation to transfer of an internet domain name, which was very sensitive, and the seller wanted to keep the rights to manage and manipulate the domain during the interim period, which was agreed. So this is what it contained. These are the key points. Obligation on the seller to transfer the domain to the escrow agent. Specific steps included in there because it will depend on the domain name registrar and what procedures are followed. The one we did was with GoDaddy. Undertaking by both parties to fully comply in the transfer. Warranties by the seller that they actually own the domain name and that they paid all fees, etc., and not breached the registrar's agreement. Then what happens? The escrow agent changes the passwords and sets itself as administrator and has an obligation not to disclose the passwords to either side. The escrow agent then sets the delegate settings, allowing the seller to do the specifically agreed management functions during the escrow period. At the end of the escrow period, the domain is of course transferred to the buyer. Again, you have to set out the specific steps. And then the tricky bit, negotiating, what happens is if there's a breach of the escrow arrangement. So if the seller breached the conditions on manipulating the domain, for example, also the escrow agent's fees, unless they're paid up front, in which case it's a non-issue. What happens if either side doesn't pay the escrow agent's fees, which are normally shared 50-50. And then other normal things like confidentiality clauses, the fact that if there's a court order or arbitration award binding the escrow agent, that will override the escrow agreement, and the usual boilerplate governing law, where the agreement should be enforced, jurisdiction, that sort of thing. So we developed this as a bespoke agreement with one of the leading escrow agents for domain names, and they think this was such a good invention they're going to market it, and we hope we'll get business out of that. So I hope that was useful, and do like the video, and thanks for watching.